first thing you need to know is what is an offer. What is an offer and what is an invitation to treat? To amount to an offer, the offerer must make a clear and unequivocal statement that he will regard himself as legally bound to perform his promise if the other party accepts his offer. However, there is a possibility for the statement to be an invitation to treat rather than an offer. For example, if you go to a shop and you see things on display, that's not an offer to you to buy them, that's an invitation to treat. In case of an invitation to treat, when you choose an object to buy, you are making an offer to the seller and the seller accepts it. So invitation to treat is a step before making an offer, whereas offer is already the sufficient step in order for it to be accepted by the seller. One part in the case of an offer, one party is the offeror who presents the offer, and the other party is the offeree, who is potential acceptor of the offer. In a problem question, you need to make sure that you explain the difference between the two and you explain why the statement given in the facts of the case is an offer or why is it an invitation to treat. Make sure you make an argument that shows clearly to the examiner why the statement is an offer or invitation to treat. Here are in this table, you can see the main differences between the two. Offer is a certain promise to be bound, clear and specific terms, the conduct or words of the party that shows certainty, and there is no room for negotiation. So this is the key. If you see in the statement that it's still not very clear, it still shows some room for negotiation, it's not written in very specific or clear terms, that should be an indication to you that it should be an invitation to treat rather than an offer. Offer is always very certain, clear, specific, and does not give room for negotiation. Here are some cases you can read after this session on this topic, and make sure you read them for you to better understand the scenarios where you should assume that it's an offer and scenarios where you should assume that it's an invitation to treat. The next step that comes after the discussion of offer and acceptance is consideration. Consideration is basically something that the party gives in exchange because law doesn't enforce gratuitous promises. In order for a legal contract to be bound on the parties, there has to be a consideration. Just offer and acceptance is not enough. So if an offeror makes an offer and the offeree accepts it, there has to be an exchange of something that has a value, but it doesn't have to be adequate. So even if it's something like a chocolate bar, as it was in one of the cases, it can be a valid consideration. So it doesn't have to be money specifically, as long as something is given in return, and as long as the promise is not free, totally free. If, for example, if A provides B with services and A gets money in return, that's very clear consideration. So there is not much ambiguity there. But you may have cases where there may be ambiguity. For example, the money was not provided in return, but something else was provided. But there are cases which shows that that there may be other objects exchanged that can be sufficient for consideration, depends on the circumstances. So make sure that you review all the relevant cases and provide adequate analysis if this is the case. But if in your problem scenario, you see that money has been given in return, then there's not much to say about consideration. You can just briefly mention that since A provided services to B and there is offer and acceptance, since the money was exchanged, there is consideration too. You can just mention it that money is consideration, but you really don't need to go into much discussion because it's obvious, it's there. Unless it was not money, but it was something else. That's where more discussion is needed for you to prove consideration. There are a few requirements for valid consideration. If these scenarios are present in the problem question that you're discussing, then you will have to discuss a little bit more for consideration and not pass to the next requirement before you make sure that you discuss all these steps. Firstly, if it's a past consideration, it's not a good consideration. If by past consideration means that if it was given in the past. Secondly, consideration must move from the promisee. So if somebody else gave consideration, if somebody else paid for the services and not the promisee, that can be a problem. And thirdly, consideration must be sufficient but not be adequate. So there must be consideration. It doesn't have to be adequate. So basically what it means is that it means that the consideration can be for something that is very valuable. It can be £1, it can be £2. It doesn't matter how much the money is, as long as it's there. It's an accepted practice in contract law that £1 transactions are made just for there to be a valid consideration. Because, as we said before, gratuitous promises are not enforced in law. Past consideration, a promise which is made after an act has been performed, is generally not enforceable as it is not supported by consideration. Consideration must move from the promisee. This gives the contract an exchange, reciprocity element. If A promises B something, B has to provide consideration. Sufficient promise to do any act or refrain from doing any act is generally sufficient. Some promises are considered void and nullity, such as counterpromise. The sufficiency of the consideration will be doubtful when the act in question consists of a duty imposed by general law, a duty imposed by a third party, a duty imposed to the promisor by contract. So basically what it means is that consideration cannot be something that is a duty imposed by general law. So if the promisee just fulfills his or her duty under the law, that cannot be consideration. It has to be something else. Even if it's a duty, a contractual duty imposed by someone else, that is also not a good consideration. It has to be something else. Well, if for an obvious consideration, there should be a monetary transaction, even if it's £1, it should be there for consideration to not be an issue. But in a problem question that you get on exams, it's very possible that you get a scenario where there was not even a monetary transaction, but it was something like something else given in consideration, and it will be on you to discuss whether or not that's a valid consideration. Cases to read on this topic is past consideration is this case, and consideration must be sufficient but need not be adequate is Williams versus Roffey. It's an interesting case. You can read about practical benefit. So basically in this case, it was argued that even if there is not a valid consideration, but in the promisee somehow obtained a practical benefit from the contract, the court may assume there is a consideration. The final requirement for the contract to be completed is intention to create legal relations, which basically means that this doctrine is based on the intention of the parties, objectively interpreted and on public policy that a law of contract ought not to intervene in domestic relations. So if in the family they make promises to each other, it's less likely that it satisfies intention to create legal relations. So if one of them sues and argues that it was a contract, it's less likely for it to be satisfied, because the fourth requirement of a contract is intention to create legal relations. And normally it is assumed that if it's not in, if we're not concerned with a commercial relationship and we're concerned with domestic situation, there is no intention to create legal relations. However, this is just a presumption that can be rebutted by arguing the opposite. So even if the promise is with someone's brother, it doesn't automatically mean that there is no intention to create legal relations. Family members obviously can have contracts, but there has to be evidence presented which proves that there is intention to create legal relations. For example, if family members sign a contract, the written contract signed can be evidence to show that there was intention to create legal relations. However, if it was just some oral conversation that happened some time and one person just made a promise to another family member, it's less likely for the court to consider that there is intention to create legal relations unless the contrary evidence is presented. In domestic agreements, clear evidence is required of an intention to create legal relations. Where a party has acted to his detriment on the faith of the agreement, a court may be more willing to conclude that the agreement was intended. So even if there is no clear evidence of the presumption to be rebutted, if one party acted on their detriment, that can be, the court would be more willing to assume that there is intention to create legal relations. In case of commercial arrangements, it's a lot easier to assume that to prove to the court that there was intention to create legal relations. Usually, it's automatically assumed. But in a problem question that you get on your exam, it's very important that you mention this. I have to identify whether or not the case scenario given to you is a commercial arrangement or a domestic arrangement, and say that whether or not intention to create legal relations is present and why. Say that if it's a domestic situation, the presumption is that there is no intention to create legal relations. And if you think that this presumption should be rebutted, say why. But if your case scenario is about a commercial setting, then you can say that the presumption is that there is intention to create legal relations. So make sure that you do not forget to mention intention to create legal relations. At the end of establishing that the contract exists, most probably in a problem question, you will have to discuss breach of contract and damages. So if you see that one of the parties in the contract breached the contract terms agreed on, if in that case the other party, the innocent party, can claim damages and can also terminate the contract, and you will have to mention that in your answer. To sum up, how do you answer a problem question on this topic, contract creation? You need to establish if there is an offer. And when establishing if there is an offer, discuss why it is an offer, the statement given to you, why is it an offer and not an invitation to treat. The clear example of what is an invitation to treat is the objects on display in a shop. The objects on display in a shop is not an offer, it's an invitation to treat. When somebody chooses the object from the shop to buy, when they go to the counter and they present the object to buy, that's when they make the offer. And when the seller accepts it, that's the acceptance. So make sure that you discuss what's an offer, what's an invitation to treat, and establish whether or not it's an offer. The next step, discuss acceptance. What is acceptance if there is acceptance in the problem question given? Third step, analyze if there is a valid consideration. If the money was transferred from the promisee, very important, if not from third party, from the promisee, in that case, there is not much to discuss. You can say that money, even it doesn't matter how much it is, even if it's £1, even if it's 1 penny, if the money is transferred, then there is a valid consideration, but you will have to mention a specific the case that established that principle, the case that established that the monetary compensation doesn't have to be adequate as long as it's there. So make sure that all your statements are supported by the relevant case law. Fourthly, discuss if the parties have intention to create legal relations. How do you do that? You identify whether or not the case scenario given to you in the problem question is a domestic or commercial setting. If it's a commercial, then presumption is that there is intention to create legal relations. If it's domestic, then there is not. However, it's not an automatic answer. The situation may suggest the contrary, and if that's the case, you will have to provide arguments. Why do you think that the general presumption should not be followed? We have a model answer provided on this topic that you can see on this link. But the first part of this model answer we can discuss now. On the 27th of March, Harry sent an email to Margaret in the following terms. I could let you have those pair of shoes we looked at for £250. Let me know as soon as possible if you want to buy them. I will be going to a shoe fair next week. Discuss the parties' contractual liability, if any, in all the following separate alternative circumstances. There are separate circumstances we need to discuss in this problem question, but we will be only discussing the first one in this session. In order to see the rest of the question, you should go and read the full answer after this session. You will receive the slides as well as the recording of this session. Margaret posts a letter to Harry on 29th of March accepting his offer. The letter has taken longer than expected in being dispatched and eventually arrives on 8th of June, 2 days after Harry has sold the shoes to Lucy. As we said, the first thing we have to discuss is if there is a valid offer. We define offer as unqualified willingness of the party to enter into the contract on stated terms. Another approach that the court can take is to hold the statement invitation to treat, as it has been suggested in the case of Carlin versus Carbolic Smokeball. Invitation to treat can be defined as expression of willingness to enter into negotiations with another party that is hoped to lead to the conclusion of a contract. In the present case, Harry sends an email to Margaret. I could let you have those pair of shoes we looked at for £250 and asks to let him know if she wants it. It can be argued that this case is not one of advertisement, Partridge versus Crittenden, or in any ways was not precise for the court to interpret it as an invitation to treat. Thus, we established that it's an offer rather than an invitation to treat because the statement by Harry was precise and it did not give any room for negotiation. It was very clear and precise. According to postal rule established in Adams versus Linsell, offer is accepted when it is posted. So as we said before, after establishing there is an offer, we need to discuss acceptance. In this case, we're concerned with postal rule because the letter was posted, and we have to discuss the relevant authority for saying what is the legal position for postal rule. Adams versus Linsell, which says that except if when the letter is posted, that's when the acceptance takes place. If Margaret posted a letter, she already made a valid acceptance, and Harry would be in breach of contract if he sold the shoes to Lucy. However, in Hampton versus Fraser, it was suggested that postal rule will only be used where it is reasonable. In modern times, where so much means of communication exists, courts are reluctant to apply the postal rule that was used in the 19th century. Therefore, in this case, it is more likely that the court will not apply the postal rule. If this approach is taken, Harry would not be in breach by selling the shoes to Lucy. In other words, we used two cases. One case suggested that the acceptance is present in this case, but the other case suggested that it may not be present according to the most recent legal position on this area, because postal rule is not often used anymore by the courts when it's not reasonable to use. So in this kind of situation where you have two cases suggesting opposite outcomes, the best way to approach this problem is to discuss both of them, discuss both cases, and say what would be the outcome if in both cases, what would be the court's conclusion if any of these cases was applied, and what is the most likely outcome if the court takes this approach. To read the full answer on this question, please go to this link after the session. These are the important cases that you're suggested to read. How can we help? So now I'd like to talk a little bit about what simple studying can do for you. Contract law can be very difficult, especially if your exams are approaching and you have very little time left to prepare. At our platform, we have the simple study resources created by the most successful law students and graduates who have very recently gotten high grades. And you and the rest of the students are able to access this simple study resources that focuses on getting high grades. You have available simple notes, model answers, tutorial videos, quizzes, and interactive learning platform to study with the rest of the community. If the resources we provide is not enough, we also offer as an additional service tutoring services, which is personalized one-to-one help for students to get some help to prepare for their assessments, and we can help you improve your legal writing skills. We have already helped thousands of students to get high grades, and we are receiving amazing feedback from them. As you can see on this feedback, we have already helped students get to high grades. We would love you to be our next student to be successful, and please join Simple Studying. Please join Simple Studying to get high grades with us. Thank you very much for attending this session.